Hello, everyone. Today we are here to discuss a very critical and important subject, that is how to make India the hub of international arbitration. To discuss this, we have with us Alkanshree, founder and managing partner of Law Offices of India. To the legal circles and to the legal fraternity, both in India and abroad, Alkanshree needs no introduction. However, for the benefit of those who have tuned in for the first time, let me introduce Alkanshree. Alkanshree had set up her legal practice about 25 years back, and today she is acknowledged to be an authority on international law, international arbitration, and international litigation, especially in the field of cybersecurity, artificial intelligence, infrastructure, and cross-border transactions. Welcome, Alkanshree. We are delighted to have you with us today, and we shall be privileged to have your perspectives, generally on the international arbitration scene, but more specifically on how to make India the hub of international arbitration.
Thank you for having me on board.
Let me begin by asking you what attracted you to the field of law, considering at the start of your career there were so many other avenues open to you. I have it from credible sources that you were a very well-known painter even in those days, and you had exhibited not only in India but in several cities, including Moscow and New York.
Interesting question, but for that I have to go back many, many years. How I started was because I think my immediate neighbor was J.V. Dadachandji, a legend. I mean, everybody who's in the legal field knows of him. So while I was pursuing my LLB, I started working with him and he used to give me assignments. And he was a very kind and a very disciplined lawyer. I still remember he used to call me up at 6 o'clock in the morning. And even without saying good morning, he used to say, Alka, do this, do that, do that. And at that time, because I was still studying and young, and I used to wonder that why is he so abrupt? Because now I realize that as a lawyer, you have so much going on that you don't have so much time to spend on niceties. You just get straight to the point. Anyway, so I worked with him, and then I also worked while I was still studying law with H.T. Shore, who we all know as the founder and which is one of the most important developments in the field of law. And then it was J.B. Dadachandji who put me through to Ryan Karanjiwala, and he said he's a bright lawyer and you learn a lot from him. And then I worked with Ryan for 2 or 3 years in the Supreme Court, and then my whole expedition started in the field of law. But it's been an interesting one till now, and I'm sure it'll continue to be so.
So the loss to the world of painting has been a gain to the world of law. Can you tell us about some of the landmark cases you have handled and the learnings you have derived from these?
There have been far too many cases that I had real fun with and we really enjoyed and we won. I think one of the cases which I would want to cite is one of the international arbitration when we had all gone to London and the entire team of Indian Oil Corporation went with us. It was Trafigura versus Indian Oil Corporation. And the Queen's Counsel at that time was Michael Brindle, which of course now these days would be King's Counsel because now we have a king there. And it was pertaining to it, so it's quite long back, but why I'm talking about it, it was pertaining to a contractual value of $110 million, which we won hands down. And there are 2-3 things very interesting which I found out. This was at the starting of my career, so that's why I'm citing that, because there are certain things which I learned should be kept in mind while working at an international case. Now, one of the things was, without taking the name, the chairman, because I wouldn't want to name that person, he was the former Solicitor General of Australia, and he was the head of the Arbitral Tribunal. And while we did our due diligence on the Arbitral Tribunal, we found out that he had written an article which could be kind of termed as racist towards Indian. So we took up the objection. We raised an objection with the tribunal, saying that, of course, we obviously, in an Indian party, they could be biased in his mind. We made a formal representation. And then he replied saying that, of course not. So, these are the things that, starting from the very inception of the arbitration proceedings, we not only look at, of course, what the matter is, and of course it has to be the whole thing has to be formulated in kind of a strategy. We also look at the tribunal, who the members are, how will they react to it in terms. They have to, of course, be as per the rules and the norms. They have to be completely transparent. They have to be not partial or biased in any way whatsoever. So these are the things that we were, like in international arbitration field, we go into the nitty gritty of it all. It's just not the merits of the matter and that's it, you argue and you come back. The whole thing has to be looked around as a good strategy. The second thing that I learned while dealing with international arbitrations much earlier on was that the backup team of the client is just as important as the counsels. In this case, which was Indian Oil Corporation, their team, we were around 5, 6, 7 of us, which flew down to London and we stayed there till the arbitral proceedings were concluded. And they were spot on. So it was so important, their inputs and the way that, they gave us the answers, and so many nuances are involved. So they were so well equipped that they made the lawyer well equipped. And I think it was a collective effort in the end. It was because of the client's team and, of course, the counsels that won the case.
Very interesting. Let us now look at the scene of international arbitration. The established seats like London, Paris, Geneva, and New York, for historical reasons, continue to be the established seats. Obviously, for reasons because they have been the seats of economic and financial activity for the last hundreds of years. But that thing aside, countries nearer home like Singapore and even Hong Kong have emerged as major destinations for international arbitration. Singapore, in fact, is positioning itself as a competitor to ICC. What, in your opinion, makes Singapore such an attractive destination? And how do you think India could emulate that? Emulate may not be the right word. How do you think India could also, if not surpass, at least be equally popular with international arbitrators?
London, Paris, Geneva, they all have emerged, and Singapore has emerged as hubs of international arbitration because historically they've always been the financial and the economical hubs in the world. And also because, like, for example, in Singapore, in SIAC, the government of Singapore has laid down very clear policy, has built a world-class infrastructure to support their arbitration activities, international arbitration activities, which gives a lot of confidence to people across the world. India could well be there. It has started. It has started in a big way with the Prime Minister Modi declaring. I think there's an international arbitration hub which has been announced in Gujarat. So we are proceeding towards it, but I think a lot more infrastructure needs to be, and a lot more promotion needs to be done to make India an international arbitration hub. In my opinion, first is, of course, we have an amazingly robust judiciary, and with equally spectacular judges and the judiciary. But I think what main concern is the enforcement of arbitration awards in India. There have been, when Justice Rohinton was in the Supreme Court, he gave out, wonderful judgments. In fact, one of them was that, I think it was Associated Builders, in which he said that arbitration awards should not be interfered with unless it doesn't shock the conscience of the court. So that means he was trying to limit the judicial interference in enforcement of the arbitration awards. Unfortunately, even now, under the cover of public policy, many arbitration awards are not enforced. And it just takes many years and a lot of litigants' time, energy, and money to agitate that. It needs to be, like, for example, in UK, an arbitration award will not be interpreted unless the error is apparent on the face of the award. So that means the grounds for interference with arbitration awards are very, very limited. I think the same needs to be done in India. Over here, now, of course, there is a definite change in the judiciary's mood, and very seldom do the judges not interfere with enforcement of the arbitration awards. But still, there's a long way to go. To what extent have these issues been addressed so far by the government of India and also other stakeholders? A lot of amendments have taken place in the arbitration field with 2019 amendments, etc. Public policy has now been defined, and not only the amendments in the Arbitration Act, a lot of pronouncements by the courts, including the High Courts and the Supreme Court, have kind of stirred the enforcement in a certain direction. Like, for example, in a matter which again was authored by, I think, Justice Rohington, in which he said that an arbitration award can only be set aside and cannot be modified. That means the court cannot really get into the nitty-gritty of it all. The court cannot, under Section 34, get into the evidence of it all, can't reassess and re-agitate the evidence. So it has to be, for any court to interfere in the enforcement of an arbitration award, it has to be blatantly be illegal, or there has to be error apparent on the face of the record. So these are good, significant developments, but also we have these in the acts. I think the more important thing would be the implementation by the courts. You see, the courts have to be much more geared towards enforcing whatever the legislature wants us to do in the arbitration field.
And what is the single most critical impediment to the enforcement of arbitral awards in India?
There are many, many reasons, of course. You really can't summarize it, but I think one of the most used objections would be it's against the public policy. But fortunately, under the amendment of 2019, that has been dealt with, it has been clarified. Like J. Burrow said, that public policy is like an unruly horse. Once astride, you don't know where it's going to lead you.
Then there's also the question of prohibitive time and costs involved, and aggrieved parties unable to pursue a claim, even if their claim is genuine, because of the lack of funds. Now, do you think if the third-party funding were to be instituted, it could resolve to some extent this problem?
Of course, one of the main concerns of the judiciary today in India is the overcrowding and too much traffic in the judiciary. And for that, we need a lot more infrastructure, a lot more judges, a lot more courtrooms. I think the courtrooms over here are overwhelmed by the sheer number of the cases that are being filed. Having said that, the other concerns are also the money and the time and the energy which a litigant has to spend in the courts. Mediation is a great alternative, but the only concern with mediation is that the decision is not binding on both the parties. Arbitration, yes, is a great alternative for dispute resolution. But again, in my view, you have to, a litigant has to go through the arbitration. And then after that, to enforce that, he again has to go to the courts. So ultimately, from arbitration, he still ends up in the court. And there can be a lot more impediments, It's just not that once you get the arbitration awards, they're the end of it. Enforcement then would be the second stage of it. And in this regard, I think third-party funding would be an excellent alternative. But my concern with that is that it needs to be regulated, and we don't see too many regulations and guidelines on it. But once those are in place, I think third-party funding would be important, because that would give the litigants the resources to be able to fight their matters in the courts in India.
India has become a major destination for overseas investment, and Indian companies are also making heavy investments abroad. In fact, the investment treaties, both bilateral and multilateral, are also generating a lot of international arbitration work. What do you think should be done to garner a greater share of settlement regime in relation to these investments? We have
numerous multilateral and bilateral treaties, but we would greatly benefit by having a model framework based on the Permanent Court of Arbitration.
As we come towards the end of this program, tell me, what has been the proudest, the most satisfying moment in your legal practice so far?
There, of course, have been many moments such as this, and I hope in future too there will be many more. But I think one which I can remember is when there was a gift of an elephant which was made by the President of India to another sovereign state. And there was this actress of Born Free Foundation in London. This was many, many years back. I can't remember all the details, but we intervened. and then the gift was cancelled because it would have been very not right for the elephant to be transported from one country to another. So there have been many such occasions and many such cases such as these. And I do hope there'll be many more in the future. I think that was one of a very satisfactory time for me.
Thus speaks an animal lover. As we conclude, I thank you once again for giving us your perspective and suggesting solutions for making India the hub of international arbitration. Thank you very much.
Thank you very much. It's been my pleasure.